This is Michael Popok, Legal AF. The answer is no. The question was asked of federal judge Luke Kaplan by Donald Trump's lawyer Alina Habba. Can we have, without having to post a bond, an extension of time and a stay of the judgment that E Jean Carroll obtained against Donald Trump through a jury for $83.5 million for punitive damages related to his continuing defame and defamation of the rape victim, E Jean Carroll? Can we have a stay of that until we get our motions filed to argue to Your Honor that the $83.5 million judgment is wrong? It should be reduced. We've got grounds for appeal and everything else, and not post a bond for the stay? Can we? No, said Luke Kaplan today on Sunday. At least no for now, but I think it means no forever. The order reads as follows and reminds Alina Habba how lackadaisical she is in trying to meet deadlines and how untimely or borderline untimely most of her actions are in the case. Remember, Alina Habba missed the boat on asking for a jury trial in the New York Attorney General case. She missed the boat on asserting immunity in this particular case. She didn't raise it for 3 years. She just is incapable, apparently, of meeting deadlines. And the judge takes special delight in his order in denying the stay without bond to say the following. 25 days after the jury verdict in this case, Judge Kaplan writes, and only shortly before the expiration of Rule 62 under the Federal Rules of Civil Procedure, automatic stay of enforcement of the judgment, Mr. Trump has moved for an administrative stay, he puts that in quotes as if I don't know what that is, of enforcement pending the filing and disposition of any post-trial motions that he may file. He seeks that relief without posting any security, meaning a bond. So the court ruled as follows. The court declines to grant any stay, much less an unsecured one, meaning without a bond being posted in the tens of millions of dollars, without first having afford plaintiff, E Jean Carroll and their counsel, a meaningful opportunity to be heard. Which means as of right now, there is no stay of the judgment. And they are dangerously close here to getting to the point where E Jean Carroll can go execute on the judgment and go grab a bank account or two from Donald Trump, which shouldn't be too hard to find given his notoriety and the public location of his assets. But so Donald Trump is risking in this small period of time through March the 2nd, which is when the judge wants the completion of briefing on this issue. In between, E Jean Carroll's lawyers could go try to execute on the judgment that is hers. There's no stay in place, no appeal bond filed until there is one. They're free to go execute. And then if they're wrong, they can give the money back. Wouldn't that be poetic justice and cosmic justice for E Jean Carroll to go grab some multi-million-dollar asset of Donald Trump's lying somewhere? Maybe they go contact Barbara Jones, who's the monitor over all things Donald Trump in the last 17 months because of the New York Attorney General case, and say, Your Honor, because she's a former federal judge, just like Luke Kaplan is a current federal judge, and say, Your Honor, we've got a judgment we want to execute. Please identify for us the location of assets up to and including $83.5 million. And she's an officer of the court, and I don't think she's going to play games and delay. Bond Charge is a holistic wellness brand with a huge range of evidence-based products to optimize your life in every way. Founded on science and inspired by nature, all Bond Charge products adopt ancestral ways of living in our modern-day world. Their extensive range of premium wellness products help you sleep better, perform better, have more energy, recover faster, balance hormones, reduce inflammation. The list is endless. My favorite product from Bond Charge is their infrared sauna blanket. Having a personal infrared sauna blanket, it's a game changer. Now, instead of trying to find out if my local gym has it, I just set it up in a minute in my bathroom or bedroom for an amazing healing treatment in the privacy of my own home. The sauna blanket works by raising heart rate to that of physical exercise, so it burns calories while you relax. You can burn up to 600 calories in just one session. Sweating helps flush out heavy metals and other toxins, and the infrared heat elevates your heart rate while relaxing, which releases endorphins and can leave you feeling euphoric after your session. It works by using infrared light, which heats the body directly rather than the air around you like a traditional sauna. This means you get the same benefits at a lower heat, and you also don't have to have your head in the heat like a traditional sauna. Enjoy a session for 30 to 40 minutes while relaxing, reading, watching TV, meditating, whatever. I've tried other products, but they simply don't work nearly as well as Bond Charge. Bond Charge infrared sauna is easy to clean up, it heats up quickly, it's super simple to use, and the lightweight design makes it perfect. Bond Charge ships worldwide in rapid time and has free shipping on every sauna blanket with no hidden costs. And it comes with 12-month warranty. Go to bondcharge.com/legalaf and use coupon code legalaf to save 15%. That's BONCHARGE.com/legalaf and use coupon code legalaf to save 15%. So Donald Trump has a problem here, a pickle of his own making, so to speak. And the judge says, I'm going to give the plaintiff, E Jean Carroll, until the 29th of February, leap year day, at 5 p.m., and I'll give the Trumpers until 5 p.m. on March 2nd, and then I'll make my ultimate decision. But you see the writing on the wall. There's no way on God's green earth that Luke Kaplan, the federal judge, is going to allow Donald Trump to post anything less than the $83.5 million plus 10% plus interest running at 9% per annum in order to stop the execution of the judgment. And as I just identified, there is a gap here where, because the 30 days will have run on all of this. And so in the meantime, we have a problem because there is a judgment in place, and she will be able to execute on that judgment in the very short interim. So if Donald Trump wants to play with fire, he's going to find out what that's worth. And because there is no stay in place, and the execution of that judgment will be able to happen in just a few days. We'll follow it here on the MeidasTouch Network and on Legal AF every Wednesday and Saturday. We'll follow the results here. We will follow what the E Jean Carroll's lawyers file and what Donald Trump files and what is finally the outcome. But you see the preliminary response by Judge Luke Kaplan, which is, I'm not giving you a stay without a bond. And I think the what's implied here is I'm not lowering the bond amount either. He was asked to do that. He was asked to lower the judgment in the first case of E Jean Carroll back in the summer when it came out at $5.5 million. They wanted to reduce it to $2.2 million. And the judge says, I don't think so. And I don't see him reducing the $83.5 million under any argument that the punitive damage component is too large a ratio of punitive damages against actual damages, because usually it's a ratio. If your actual damages in this case are $17.5 million or whatever it was, there's a multiple of that the jury can award in punitive damages. But I think they're right within the range of what's appropriate for punitive damages under United States Supreme Court precedent about how big of a punitive damage award versus an actual damage award a jury can award. We'll follow it here on the MeidasTouch Network and on Legal AF and on my next hot take. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.